So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Time is reporting that Tesla is facing a racism lawsuit in its Fremont factory, and we've got to talk about it. It says that there's nearly 6,000 black workers that are affected, and the Fremont factory is actually a really interesting one that I want to give a little bit of context to before we get going. So this factory actually was originally the NUMMI factory, and anyone kind of familiar with NUMMI or with had a business degree or something of that nature is familiar with this factory because it was a disastrous joint venture of General Motors and Toyota's back in 1984. It really was an interesting setup, and that's why I'm just highlighting here. They peaked at 2000 in 2006 at 428,000 vehicles. But this site was considered, quote, one of the worst workforces in the automobile industry in the United States. And that was from the United Workers in and of itself. The idea behind it being a joint venture was that General Motors was wanting to learn the Toyota production system and the Toyota way. It's a series of lean manufacturing philosophies that made Toyota one of the best of its time in the 80s, early 90s. And so the American companies saw that Toyota was doing really well, outcompeting them, and wanted to implement that at the NUMMI plant. They were going to learn from each other. And it was really a weird decision to even remake the NUMMI plant. The Fremont Assembly, they hired much of the same people. Toyota ultimately thought that they could change things around, but in the beginning workforce in 1982, 85% of the initial workforce was laid off. And again, it eventually was defunct in 2010 and then sold to Tesla, which is where we're at today. Noel Wise, who's the Alameda County Superior Court judge, said that workers have to continue with their class action because it seems that there was a pattern or practice of failing to take reasonable steps. And so we're going to talk first about the initial lawsuit filed by Tesla worker Marcus Vaughn. And I want to highlight this first because it's actually a lesson for many business owners. Marcus Vaughn was actually not a Tesla worker, as this Time article suggests. Marcus Vaughn was a temporary worker working for some third party, unknown specifically. Tesla offered him a job on October 18th, 2017 with an offer letter. It gave him an arbitration agreement and said that they need to accept that Marcus needs to accept, and that he needs to sign before November 6th, 2017, and basically that Marcus would become a Tesla employee. But Marcus didn't want to, partially at least because of the abuse that he received in his role as a temporary worker, as a third party temporary worker. And he was really sort of, some of this abuse was quite serious and quite terrible. And so Marcus Vaughn decided not to. In the letter, also had an arbitration agreement saying that if you disagreed, we can go through arbitration. Arbitration, of course, is a third party in theory that is supposed to decide the matter between the two. But Marcus said, no, I didn't ever agree to arbitration. I never signed the offer letter, and as a result, arbitration doesn't apply. And again, I wanted to highlight here a little bit because Tesla considered themselves an employer for Marcus Vaughn, even though he was not actually an employee of Tesla. Because Tesla owned NUMMI, they had a managerial role in the facility. They could hire, fire, and discipline. And as a result, they're a joint employer. And many employers need to understand the nature of joint employer. It's something that is really on the mind of the NLRB, the DOL in general. And so it's something that, if you're not familiar with joint employer status, you need to be. Late last year, the Equal Employment Opportunity Commission sued Tesla for this harassment that was going on. And in the suit, the black employees at the Fremont factory regularly received abuse, very serious stereotyping, hostility, encountering graffiti, etc. It was pretty significant. And so the EEOC, when they dug into it, raised objections and decided to sue them. It was again a very substantial lawsuit. And it was one that, the EEOC San Francisco District Office Director Nancy Cienko said, when you let a standard slip, you set a new standard, determining that prolific racial slurs do not merit serious discipline and failing to correct harassing conduct sends an entirely wrong message to employees. It also violates an employer's legal responsibility to act swiftly and effectively to stop race-based harassment. So the EEOC has determined to take this through with them. This is an effectively old situation that has been going through the courts for a long time. What do you think about that? EEOC has said that they've been experiencing these issues for at least almost 9 years, and have not taken any kind of under many presidents, have not taken any sort of role in this abuse that has been going on throughout this time frame. What are they doing if they think that this is, if they understand that this is very important? It seems like they're not fulfilling their piece of the pie. Let me know in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.